We all learned that British soldiers could just waltz into your colonial home, sit down at your table, and eat your dinner. That's basically the story behind the Third Amendment. And that image, the one you're picturing right now, is almost entirely wrong. And that single misunderstanding changes everything about why the founders actually wrote it, and why this tiny, forgotten amendment might be secretly protecting you right now. We're going to break down what the Quartering Acts actually said, what the founders were really scared of, and how a law about soldiers in bedrooms later became a cornerstone of your right to privacy, all the way into the digital age. Stick around, because by the end of this, that 28-word amendment you've probably never thought about is going to look completely different. All right, let's go back. It's 1765. Britain just finished the 7 Years' War, what Americans call the French and Indian War, and they are flat broke. They had tens of thousands of soldiers in North America, and no good way to house them. So Parliament passed the Quartering Act of 1765, and here is where the myth explodes. Because that law did not say soldiers could move into your home. It required colonial governments, not private families, to pay for barracks, inns, and public lodging. So basically, it was more like a forced tax on the colonial government than a home invasion. The colonies had to fund soldier lodging, even if they hadn't voted for it. New York actually refused to comply and had their legislative powers suspended as a result. Then 1774 arrives, and things escalate hard. The new Quartering Act, passed as part of the Intolerable Acts, gave royal governors more power to find lodging, bypassing colonial legislatures almost entirely. And even then, even in 1774, the law still specifically did not allow soldiers to be forced into occupied private homes the way everyone pictures it. So when the revolution ended and the founders sat down to write the Bill of Rights, the anger wasn't really about specific bedrooms. It was about a principle. The principle: military power should not be planted inside civilian domestic life without consent. Government force stays outside your door. James Madison introduced what became the Third Amendment in the House in 1789. It was ratified on December 15, 1791, as part of the Bill of Rights. 28 words, the whole thing. And legal scholars almost immediately started calling it the Forgotten Amendment because for about 170 years, almost nothing happened with it. The Supreme Court has never built a major standalone ruling entirely on the Third Amendment. Never. Until 1965. When, of all things, a birth control case changed everything. Connecticut had a law banning contraceptives, even for married couples. Estelle Griswold, director of the Planned Parenthood League of Connecticut, and Dr. C. Lee Buxton were arrested for providing contraceptive advice to married patients. And here's the thing. The Third Amendment is literally part of why the Supreme Court said that arrest was unconstitutional. I genuinely want to know, did you have any idea the Third Amendment was connected to birth control law? Drop it in the comments, because I'm betting most people are completely blindsided by this. The Supreme Court struck down Connecticut's law 7-2 in Griswold versus Connecticut, but because the Constitution doesn't say right to privacy anywhere, Justice William O. Douglas had to build the argument from scratch. He said the Bill of Rights creates penumbras, protective shadows, where implied rights live. And the First, Third, Fourth, Fifth, and Ninth Amendments together cast a shadow of privacy protection around your personal life. The logic is direct. If the government can't physically station a soldier in your home to monitor your activities, then the spirit of that protection means the government can't intrude on your private domestic life in other fundamental ways either. Now, here's where I need you to really think about this, because this is where it hits home today. If the government can't put a soldier in your house, should they be allowed to put a digital soldier in your phone? Because that is exactly the conversation legal scholars are now having about data privacy, digital surveillance, and digital rights in the modern constitutional era. Most of that legal debate plays out through the Fourth Amendment in actual courts today. But the Third Amendment is part of the constitutional DNA that started that whole conversation. And then, in 1982, completely out of nowhere, somebody actually tried to use the Third Amendment in a real case. And they weren't even homeowners. In Engblom versus Carey, New York prison guards went on strike in 1979. The state activated the National Guard to cover their duties, and then evicted the striking guards from their employee housing on the prison grounds to billet the troops instead. The guards sued under the Third Amendment, and the Second Circuit Court of Appeals made 3 rulings that had never been established before. 1. National Guard troops count as soldiers under the Third Amendment. 2. The Third Amendment applies to state governments, not just the federal government. 3. And this is the wild one. You don't have to own the property to be protected. If you have a lawful right to live somewhere and exclude others, the amendment can apply to you too. So no, the Third Amendment is not just a weird footnote about soldiers and bedrooms. It's a rule about consent, about where government power ends and private life begins. It quietly underpins the constitutional right to privacy. It expanded to cover state governments and renters in 1982, and some of the sharpest legal minds today think its core principle, your private space is not state property, matters more than ever in the age of data privacy and digital surveillance. The most forgotten amendment might actually be doing some of the most important work. If this changed how you see it, hit like, subscribe, and check out the next one.